So when I talk to clients about wills, I always talk to them about other documents such as powers of attorney documents. What I often get asked, what is a general power of attorney? A general power of attorney is a legal document that allows you to nominate one or more attorneys to act on your behalf for financial matters only. The attorney's power ceases if for any reason you lose the capacity to manage your own affairs. A general power of attorney is typically used to give someone specific authority in a commercial transaction or to pay bills while you're overseas. The other question is, what is the difference between an enduring power of attorney and a general power of attorney? Unlike a general power of attorney, the power of attorney under an enduring power of attorney document continues even if you lose capacity to make decisions for yourself. An enduring power of attorney allows you to give your attorney the power to make financial decisions and health and personal decisions as well. Why should I make an enduring power of attorney? Is often asked. If you're over 18 years of age or older, you should make an enduring power of attorney. If there comes a time when you are unable to manage your own affairs, it may be too late to make your wishes clear to those who will care for you. The best way to provide peace of mind is to legally appoint someone to manage your financial and personal and health matters in case you are unable to do so in the future. What would happen if I lost capacity and didn't have an attorney to act for me? If there are matters that require formal authority or if there are disagreements between your family members, an application may need to be made to the Queensland Civil and Administrative Tribunal for an appointment of an administrator and/or guardian. There is a risk that the person or organisation appointed, for example the adult guardian, is someone that you do not want looking after your matters. What are my attorney's responsibilities? All attorneys must act with honesty and care. In exercising their power, they must recognise your right to confidentiality and dignity, respect your views and take into account any existing relationships, values and culture. You can nominate one or more attorneys to be both your financial attorney and personal or health attorney. You can nominate different people for each role. A financial attorney is responsible for financial matters, including paying bills, receiving income, taxation and legal matters, investment and financial planning and property management. A financial attorney must keep records of dealings and transactions, keep your property separate from their own property unless it is jointly owned, and avoid transactions that conflict with their interests with yours. A personal health attorney is responsible for making decisions in relation to where you live, who you live with, daily issues like diet and dress, and giving approval for you to receive certain types of healthcare. A personal or health attorney must take into account the advice of your doctor, healthcare provider, and ensure that any decision you make contributes to your health and well-being, and must choose the least intrusive treatment when there is a choice. Who should I appoint as my attorneys? It's very important for you to choose people that you trust as decisions made on your behalf are legally binding. You should be over 18 years of age. If you have a carer who receives a carer's pension or similar government benefit, they must be the right person to appoint. Your attorney should not be a doctor or nurse or anyone who is paid to care for you. For personal and healthcare matters, it's important to choose a close family member or friend who is aware of your personal and healthcare needs and wishes. If there is no one available, the adult guardian can be appointed to look after the interests of people with impaired capacity. The adult guardian is an independent statutory officer. What powers should my attorneys have? Your attorneys will be able to make any decisions that you can make for yourself unless you provide specific limitations in your enduring power of attorney. What should I do if I have an attorney who is not acting properly? Anyone who suspects that the power of attorney is not being exercised properly can inform the adult guardian. The adult guardian has the power to protect your interests if you are unable to do so yourself. Your attorney may be required to provide accounts and details about any decisions that have been made. An attorney who does not protect your interests adequately can be replaced. The adult guardian can be contacted by phoning 1300 653 187 or emailing adult.guardian@justice.qld.gov.au or publicguardian@publicguardian.qld.gov.au. When does the enduring power of attorney begin? For financial matters, you specify when you want your powers for financial attorney to begin. This could be immediately, on a particular date or particular occasion, such as if you lose capacity. We can help you clarify the clauses you will need to put in place for your particular situation. Personal and health matters. Decisions about personal and healthcare matters will remain in your hands unless for some reason you lose capacity or the ability to make decisions for yourself or communicate them. If there does come a time you need the assistance of your attorney to make personal and healthcare decisions, they are still obliged to help you make decisions yourself to the fullest extent possible. When does the enduring power of attorney cease? There are a number of situations under which an enduring power of attorney may cease to be effective. These include if you get married, unless your new spouse is already your attorney, if your attorney withdraws, if you die or your attorney dies, if you get divorced, if a provision made to your former spouse is revoked, if if you revoke your enduring power of attorney, if your attorney becomes your paid carer or healthcare provider, if your attorney becomes incapable, if your attorney becomes insolvent, if you make an inconsistent document, like the enduring power of attorney is revoked to the extent of any inconsistency with any later document you may complete.